Hello and welcome to another primary source close read. My name is Josh, and today I'm excited to be joined again by our scholar, Tony Williams. Hey, Tony.
Josh, how are you? Hello, everyone.
Great. So, Tony, I'm excited today because we're going to be talking about the free exercise clause. Now, BRI is going to be releasing a new homework help video soon on the free exercise clause, in which we take a look at the history of that clause, as well as some Supreme Court case rulings on it. So I thought today, though, that we could actually do a deeper dive into it and look at some opinions, primary source excerpts, and of course also dive into the history of the free exercise clause. Let's start out by just looking at our broad constitutional question here, which is what constitutes the free exercise of religion? So this has been a perennial question throughout American history. What does it mean to exercise a religion? Does that just include believing something? Does it mean, are you able to act in order to exercise a religion? So there have been many cases, and we're just picking out a couple of them today. So let's start off by taking a look at the actual clause. So Congress shall make no law prohibiting the free exercise of religion. Tony, why did the founders include this in the Bill of Rights? What's the history behind this?
Right, thanks, John. I mean, you're absolutely right, right? So it constitutes the essential belief among the founders that religious freedom, religious liberty, was a basic inalienable right of man, right? It is really critical to that duality of civil and religious liberty. In addition to that, though, it's not only a sincerely held belief of conscience, which is a natural right, but the ability to exercise, right? Whether it's to practice the sacraments or to pray or to exercise, sort of the religious belief in practice, essential to, whatever religion you hold. So yeah, the inseparable idea of religious liberty as a natural right, as a matter of conscience, but also exercising, practicing that religion. The government cannot restrict that, one of the most basic rights of human beings.
Great, yeah, and it seems pretty clear cut there when you put it that way, right? But of course, as we've seen, then it kind of gets gray in some areas, right? Because then it becomes a question of, well, is the government able to regulate this at all? How much are they able to regulate, et cetera? So the first case we're going to look at is Cantwell v. Connecticut. And that involves religious solicitation, I believe. Tony, could you give some background on what happened in that case?
Yeah, very simply. I mean, the government sought to not only regulate but prohibit Jehovah's Witnesses from going door to door and talking about their religion and handing out some religious literature and so forth. And a Catholic community was particularly aggrieved by this and wanted to put an end to it.
Great, yeah, and this case actually incorporated the free exercise clause to apply to the state governments, which in the modern day, that's we kind of take it for granted that, yeah, the Bill of Rights applies to the state governments, but initially it wasn't set up that way. It initially only applied to the federal government, and it wasn't until the 20th century that the Supreme Court started to apply the Bill of Rights to state governments through the doctrine of incorporation. So we have here an excerpt from Justice Owen Roberts. So the court did end up ruling in favor of the Jehovah's Witnesses. Tony, what do you take away from this ruling here?
What I take away is that the government can regulate certain things about religion related to good citizenship and to civil society and so forth. It can pass laws kind of around the edges. For example, we wouldn't want someone knocking on our door at 2 a.m. Trying to persuade us to join their religion, for example. That wouldn't be very good citizenship. It wouldn't be very neighborly. However, the government cannot single out, right, any particular religion or religions in general and say you cannot solicit, right? Maybe your Boy and Girl Scouts can in the neighborhood, or some businesses, or the local football team is trying to raise money and so they're going to door, or maybe a political candidate. So the government can kind of pass regulations on solicitation. You can't do it at 2 a.m., for example. But it cannot single out a religious group to put a substantial burden upon that group. So, I think all this is pretty clear cut, but it does raise interesting questions to say, where can the government regulate things exactly? Because there's some interest, right? There's some compelling interest that the state or the government has in regulating behavior. But in this case, it was really singling out a religion, which is not permissible.
Great. Yeah. I guess maybe one thing that you could say maybe the government has a compelling interest in is when it comes to unemployment benefits, which is actually what conveniently the next case we're going to look at is Sherbert v. Verner. So what happened in this case, Tony?
Right. Well, this was related to Seventh-day Adventists, which did not work on Saturday because that was their Sabbath day, right? And so the idea was that they would lose their job and therefore unemployment benefits because they were unwilling to work on their Sabbath, which in the end. The court decided that this was an unfair imposition, that this singled out the Seventh-day Adventists for practicing their religion, and therefore this was an undue burden on them, and therefore they were indeed entitled to receive those unemployment benefits.
Great, yeah, and it's interesting here just in the wording of this decision. Again, like you said, that undue burden, the court is framing it that they're really making her choose between her religion and basically, being able to survive by having money. And so just the way they frame that, they are saying this is indeed preventing her from freely exercising her religion. Is that a fair way of putting it?
Yeah, exactly. And again, we need to think about other examples. Could the state impose a burden on someone who just wanted to have Saturdays off, or maybe watch football on Sunday or something to that effect. These are not reasonable excuses, right? But when it's burdening religion and religious freedom, which is protected, and that exercise of religion, when that's protected under the First Amendment, that has a special protection that, as you said, the government can't pass an undue burden on.
Great, yeah. So these two have actually, the court has ruled that the government was violating the First Amendment. This next one, it's actually going to rule in favor of the government in this case of Employment Division v. Smith. This case involved an individual, again, who was being denied unemployment benefits. Is that correct, Tony? But for a very different reason.
Right. So the people who were suing for benefits, which they had lost, had used peyote, hallucinogenic drug that was banned by federal law, and they said it was part of their native religious practices. Okay, and This is a very, very interesting case and a famous case. And, what the court decides in the end is that having, a drug law, whether people agree with it or not, and a lot of these drug laws are being very heavily debated today. And in fact, I know BRI has had some programs and opportunities to debate this. But, if there is a federal law banning, the use of marijuana or other drugs, and, people participate in it, they, and they lose their job, and they lose their unemployment benefits. Basically, what the government is, what the court is saying in this particular case is that's acceptable. Not, it needs to balance, these laws with religious freedom. And in this case, the court decided that since the drug laws apply to everyone, it wasn't unfairly burdening religion because it didn't target only religious practices. It banned, all citizens from using these illegal drugs.
Right. Yeah. Yeah. And you see in this excerpt that tension between that comes up sometimes, the social importance of laws versus, religious beliefs, that comes up sometimes. Maybe one thing that comes to mind is Wisconsin v. Yoder, where the state of Wisconsin said we have a compelling interest to require students to go to public school until I think age 16. And then this Amish family said, well, that violates our religious beliefs. So, and the court needs to decide how can we best balance between, the community's interests as well as the very important individual interest in exercising religious belief. So we're gonna finish then. We have one more case. This one is actually going to involve schools and funding. Tony, what, actually taxes, I should say, not funding directly, but what happened in this case?
Yeah, this had to do with state money going to, tax credits money going to individuals for sort of private nonprofit organizations for their participation in them. And some of this money, of course, went to, a Christian academy. And the question was, is this allowed? And this is an interesting case because, it can show some of the tension between, the Establishment Clause on one hand and the Free Exercise Clause on the other. So in other words, we've talked about the Establishment Clause and, the government, regulating, prayer in schools or maybe at commencement ceremonies, maybe at a high school game in Texas, for example. And, we do need to recognize that, religious liberty and, the Establishment Clause, can sometimes be in tension. If you're banning something because of, the so-called separation of church state, the establishment doctrine, that bumps up against, an individual or a group's right to practice their religion. So sometimes there can be tension in that. And in this case, there was that tension between, let's say, supporting the school indirectly or supporting the students who attended that school and their right to attend that, their ability to attend that school as, part of their religious upbringing. And so those were in tension. But again, the court decides that the government cannot single out religion or religious schools with their laws, so with their regulations, and so upholds the young person's ability to attend this religious school. Right.
Great. Yeah, and this case was of the four we looked at, this was the closest decision. This one was 5-4. And as we like to do in these videos, we also like to pull from the dissenting opinion to show that these are rarely unanimous. There are multiple perspectives approaching this. So we have an excerpt here from Justice Breyer, who dissented. And this kind of gets to what you had been saying initially about that. They're kind of approaching it from both the Establishment Clause and the Free Exercise Clause. So here Breyer's talking about, we have this concern about the state funding religious teaching, because that would, of course, infringe on the Establishment Clause. So do you think, are the justices just speaking an entirely different language here? Or what do you think, Tony?
Well, I think as with, many cases and with many lawsuits, or even principles, people are approaching it from different angles, right? So they are looking at the facts of the case and interpreting, things a little bit differently, and that's the way it should be. And as you said, in this case, maybe coming from things from more of an Establishment Clause point of view, but the majority of the justices do decide for religious liberty in this case, and this tension isn't necessarily going away, right? I think the court has done, I think, is sort of to look back on our history, a pretty good job in terms of protecting religious liberty and the Free Exercise Clause. And there are various movements afoot to sort of restrict that, or take away tax exemption status or tax church property and so forth. And these cases aren't necessarily going to go away. But I think the court will continue to defend religious liberty in a lot of those cases. So expect more cases on the horizon as these perennial issues just maybe don't go away.
Yeah, I'm sure the Supreme Court will never reach a day where they have no more cases coming to them on religious liberty. So let's go back to our original question. What constitutes the free exercise of religion? So we've talked about 4 cases here, Tony. Just in a quick summary, what has the court ruled? If you could just give me a couple sentences, how have they determined, based on these 4 cases, what is a free exercise of religion? And in the case of Employment Division v. Smith, why was that not a free exercise of religion?
I think that the court has by and large supported that unanimity among most of the founders, with not only Jefferson and Madison, but also Washington and others, who believed that religious liberty, that this free exercise of religion, was an inherent natural right. And so you see time again the court trying to balance the legitimate interests of the state with having a harmonious and just civil society with the free exercise of religion. And I think by and large the court, at least in the cases that we've seen today and in some other cases, has come down firmly on protecting religious liberty and ensuring that people have that freedom of conscience, and also the ability to exercise those ideas in a reasonable way that's protected.
Great. Yeah, well put, Tony. Well, thank you everyone for joining. As I previously mentioned, BRI is soon going to be releasing a new homework help video on the Free Exercise Clause. So be sure to check that out when it does come out. As always, you can join our conversation on Facebook, Twitter, and Instagram for updates on our programs, events, and ways to get involved. And of course, we would love to hear from you. So please comment your thoughts on the video below, or get in touch with us on social media. Tony, thanks again for joining me today.
An important and interesting discussion. So thank you, Josh.